The Judicial Services Commission interviews have again not gone without criticism. The process has been blasted for being unfair and lacking credibility, for excluding some of South Africa's top lawyers. This, of course, follows another complaint that resulted in the High Court ruling setting aside April's ConCourt judges' interviews. Let's speak to the Commission's spokesperson, that's Advocate Dali Mpofu, about some of the outcomes of the interviews from last week, as well as some of the criticism that is being levelled at the processes that have taken place. Advocate Dali Mpofu, we'll get into the criticisms in a moment, but just, let's start on the positive note. Your critics, well, at least the critics of the previous round of interviews, many of them are coming out. KSEC has come out, Judges Matter have come out, and they've said that this was a much better run process, much fairer in terms of how the candidates were treated. What's your sense as the JSC? Are you satisfied with the manner in which the process was conducted, and that some of the criticism from April was taken on board?
Yeah, no, we're very satisfied, and we're happy that they have come out. I've not seen the places where, as you say, we were blasted, but the ones that were, the comments that I've seen were quite positive. And and the issues that were dealt with this round were the same as those that were the previous round. The only issue that had been taken to task for was the issue of the deliberations, that the deliberations had not been extensive enough, not so much the interviews. So the interviews themselves were never an issue. Yeah. But and I think that everyone was happy that we had the interviews. We want to make it quite clear, we never considered that the issues raised by KSEC were valid. But we, as a public body, had to look into the bigger picture, and we felt that we should settle the case in the broader interests of the country and of the Constitutional Court. Because had we litigated, even if we thought we were right, and litigated and would become successful, quote unquote, it would have worked against the interests of the Constitutional Court, because the litigation might have taken 3 years to 5 years. And such a victory would have meant that the Constitutional Court would remain with vacancies for that number of years, which cannot be in anybody's interest.
So can we, as South Africans, then be assured that this time around there was extensive deliberation after the interviews were done and dusted, that it wasn't simply a matter of, one person, one commissioner arriving with a list and saying, obviously, these are the most qualified names, and all of you saying, as they would say in isiZulu, elethu, and you all just agree and submit those names forward those names to the president?
Yeah, look, it's debatable as to whether there's anything wrong with, if you are in a panel and somebody comes up with an idea that you agree with, whether you actually have to then voice or say anything. But yes, the direct answer to your question is that, yeah, the deliberations were there, and we had a different chairperson as it happened. And if anybody wants a copy of the deliberations, they will get them, presumably, if there's going to be any litigation, which I doubt. There shouldn't be. If there's any legitimate concerns, at least the parties that had expressed those concerns seem to be happy now.
So just tell me about the names that you have forwarded, the names of Judges Thulasizwe Simelane, Judge Kolapen, Judge Matopo, Molemela, and Bashir Vali. It's the same names that you had forwarded after the April interviews. And I know that they come from various streams of experience and the work that they've done. But what was the thread that ran through it? What were the main considerations that led to you being convinced that these are the 5 names from which the president can select 2 to fill those 2 vacancies at the ConCourt?
Well, broadly speaking, that is why the interviews are done in public. So people would have picked up the kinds of consistent questions that were being asked. But broadly speaking, the starting point is obviously the fitness of the person to do the job. And that goes to issues of their experience, the kinds of judgments that they've given, the acting stints in the Constitutional Court become helpful because obviously, I think as one of the candidates said, if she had not acted, she would not even have applied because she might not have known what she's in for. The pedigree, just the general pedigree, some of the people are currently in the Constitutional Court, averagely about 10 years on the bench. It's those kinds of issues. But then there are constitutional imperatives which are spelled out in Section 174 of the Constitution. Issues of race and gender, those are spelled out in the Constitution. And those must be weighed in with what I call the general fitness questions. And some people had good interviews around those issues. But it's a complicated weighing process, Thulas. It's not one, there's no silver bullet point. So you might be experienced, but maybe not in constitutional issues generally, or you might have had judgments that have been questioned, or you might have judgments that have not been questioned, and a whole variety of issues. Yeah, it's not as easy as it looks.
Sure. So my intro talks about you being blasted, and you said it's debatable whether you've been blasted. Let me refer to the editorial of the Business Day from Friday, where they're talking about the exclusion of a person that they consider to have been possibly the most qualified person, this being Judge David Unterhalter. His exclusion, they say, shows that extrajudicial considerations and considerations beyond the normal, fit and proper arguments went into that consideration. And also, while you answered that, you made reference to that Section 174, which requires, in peremptory terms, that, the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are considered. What do you say to that?
Well, I start exactly where you've left it off. Most of these so-called criticisms are based on complete ignorance, for example, of Section 174(2). So for them, it's as if the Judicial Service Commission elects to take into consideration race or gender. Well, if they don't want that to happen, then it cannot be changed in an editorial of the Business Day. Then they must agitate for constitutional amendment. Then we won't take into account those kinds of factors. But as far as suitability is concerned, I don't know on what criteria they evaluate the candidates. Because if you look at the number of years on the bench, the candidates that they seem to be campaigning for had the least experience. If you look at the issue of acting at the Constitutional Court, the candidates, once again, of the 5 candidates that were selected, I think only one had not acted. All of them had acted there, some of them for long periods. Yeah. So, I don't think we can be moved by a partisan analysis that looks into only one criterion, which is race, and not look into suitability in the broad manner that I have explained.
But I suppose what the argument is, if we take it to its full extent, is that at the moment, if you look at the Constitutional Court at least, not the other superior courts, there isn't a person who is a white male judge at the Concord substantively appointed. You've had people in an acting capacity from time to time. And I'm not even sure if we have a white woman judge in the Constitutional Court, which would talk to this Section 174, that broadly the racial and gender composition of South Africa must be reflected.
Yes, but I mean, that's, I suppose it's a question of how you view the historical imperatives of South Africa. There's no white quota in the Constitutional Court. What we're trying to deal with is the exclusion of black people and women in the past in the Constitutional Court and other courts. But let me just say, for example, Thulas, the most important thing is that the people who criticize the JSC typically would be people who look at it very narrowly. So they might look at what happened on Monday as opposed to what happened on Tuesday, for example. On Tuesday, we selected, I think, 3 or 4 white persons or 5 in the Gauteng bench, and nobody said now we're anti-white or anti-white male even. So I don't think that we will ever reach a situation which logically is where these people really want us, where we select someone simply because they are white and male. That will never happen. I think that they must just accept that, which is not the same thing as saying whites and males do not have a place to be selected if on the other factors they do qualify. Yeah.
All right, makes sense. Thank you for that. Advocate Dali Mpofu speaks on behalf of the Judicial Services Commission. Thank you for engaging me there, the Advocate Dali Mpofu, talking about the processes that have been happening at the Judicial Services Commission around the appointment of judges to fill vacancies at the Constitutional Court.